A mock, yeah, it does. Just take it on. Yeah.
Okay. All right. Welcome, everybody, to the continuation of our speaker series on investment law and policy. Thanks to Crowell & Waring and Baker McKenzie, who have convened the most wonderful, helped us to bring the most wonderful lineup of speakers this fall. And I'm particularly excited to hear from Annette today, Annette Magnusson, with whom we've discussed these incredibly interesting projects. So I'm taking today as an opportunity for updates. Annette Magnusson is the Secretary General of the Arbitration Institute at the Stockholm Chamber of Commerce and the General Counsel of the Stockholm Chamber of Commerce, where you've been for a while at the Stockholm Chamber of Commerce, right? Many years. And I just want to make a note for the discussion afterwards that today's session is being webcast, just so you know. So thank you so much, and I will turn it over to you. I don't think you need this.
So thank you very much. Thank you, Lisa, for the introduction, and thank you so much for the invitation to be here and speak today. It's really nice to speak in such a full room as this today. My talk here today and the title of my talk here today reflects the title of a chapter that I have submitted to a book that will be released early next year called International Arbitration in the Energy Sector, which will be edited by Max Shearer at Queen Mary University in London. So here's my pitch for the day. That's the title. But the content, obviously, this is a brief talk, so I will pick some parts from this chapter. And if you want to have sort of a full overview of the topics that I'm picking here, you can wait for the publication of the book. But I will have three parts of my talk here today. First, I will address a few observations, what I call the legal framework for sustainable development in the energy sector, and particularly looking at the enforcement regime of this framework. Then I will go through a few examples of using other legal instruments to argue cases that could be said to be associated with sustainability objectives, targets. And last, I will take a look at the needed investments to meet the sustainability targets in the future. What has been said about that? And in closing, and I think that was what Lisa was alluding to, at closing I will offer a proposal on perhaps how to connect the dots between these three observations and perhaps in the future achieve an even stronger enforcement regime for sustainability targets. And this is an initiative that we call the Stockholm Treaty Lab. So I will come back to that. But first, maybe I should say a few words and explain why is the Secretary General of an arbitral institution addressing you on this topic today. I have received the question many times, why are you talking about this? Or why are you talking about this? Or like a colleague at the Chamber of Commerce said a few years ago as we set out on this journey, do they know we're doing this? And I think that sort of comment came from the perception, which is, I think, rests on a misunderstanding that there is some sort of a conflict between economic development on the one hand and meeting sustainability targets on the other hand. And I think that conflict has been voiced in sustainability objectives at large, but also when it comes to climate change mitigation and adaptation measures. But I think this is an outdated view, and I think probably most of you in this room would agree with me. I hope you would agree with me. I think there will be no sustainability, there will be no climate change mitigation and adaptation if there is no economic development. As many of you might know, at the SCC we see a large number of investment treaty cases, international arbitration based on investment protection treaties. Since our first so-called ISDS case in 1993, we have seen more than 90 ISDS cases in Stockholm. And about 2/3 of these cases have been decided under bilateral investment treaties and about 1/3 under the Energy Charter Treaty. And the majority of these cases have been heard under the SCC rules, our own arbitration rules, but we also see cases under the UNCITRAL arbitration rules, and we also act as appointing authority in ad hoc arbitrations seated in Sweden. So these figures makes SCC to the second largest institution globally for the handling of ISDS cases under our own set of rules, second only to ICSID in Washington, D.C. in absolute numbers, ICSID is by far larger than the SEC, but it's interesting to note that nations have placed such confidence in a small country in Northern Europe to handle their investment treaty arbitrations, and that has sort of propelled Stockholm to this position. There are a number, illustrating this position of the SEC rules, there are a number of moot court competitions being decided, including under addressing investment arbitration under the SEC rules. There's one coming up later this year. And I hear there is still room for both teams and arbitrators, so you're interested, let me know afterwards. But against this background of us managing all these ISDS cases, we also became quite involved when the so-called ISDS debate really started a few years ago. It had been going on for some time, sort of a discussion about the ISDS regime, but I think particularly with the beginning of the negotiation of the TTIP between the European and the United States, that's sort of when this strong discussion really got momentum. And in essence, our stance in what I choose to call this media storm has been to look at the value of international arbitration as such. So we have been focusing on explaining the role played by international arbitration as a vehicle for international trade, as a vehicle for economic development, and in the end, for peaceful relations among nations. We have not been debating the content or the value or the drafting of the substantive terms of the treaties, the investment protection provisions as such. We believe that is not and has not been our role as an arbitral institution. This is sort of different part of these treaties. We have been focusing on the procedural side of these treaties. But we have made some observations, if you want to call it that, if you're looking at the substantive terms of the treaties. And these are observations that I think to some extent emanates from switched in silos. And then you wonder, what silos? Well, the first silo that we were sort of, is our own silo, so to speak. You could call this the ISDS silo, the International Investment Law silo. In this silo, very, very strong voices have been heard being very upset about the fact that states are bound by the international obligations. And to the extent that if they do not live up to the obligations or the promise they have made in these international treaties, primarily bilateral investment treaties, they can be held responsible before an international tribunal that can render a decision that can be enforceable in a domestic court of law. This fact that states have been bound, or are bound by the international treaties to this extent, have been argued to being a threat towards the environment, and the fact that the states are bound to this extent, that is preventing the states from fulfilling or for taking measures to protect the environment. So therefore, in this silo, the fact that the states have been bound by the obligations to the extent that they are in international investment law has been deemed like a threat to the environment. On a side note, we have been looking at this from the SEC, and we see that less than 10% of the known are ISDS cases that have been decided actually do emanate from environmental measures. But I think I will not go further into that. I think that's a different talk rather than what we're having here today. But one should remember that this feature of this first silo, the fact that states are bound by the international obligations to this extent, is very unique from an international law context. The manner in which states are bound by the international obligations. That you can truly enforce the terms of the treaties that they have entered into is unique for this silo. So moving then into the second silo, which is sort of the international environmental law silo. Now, the very same voices that are very upset in this silo, that states are bound by the international agreements to the extent I just described, in this silo, they are very upset that the states are not bound by the international obligations. Because international environmental law does not contain language to the same binding structure that you would find in bilateral investment treaty or an energy charter treaty or the NAFTA for that matter. So with this two experience from these two silos, I thought to myself, we need to cross-fertilize the experiences from these silos. Rather than looking at the fact that states are bound and saying that that is a bad thing, we should be looking at, if you are making a commitment in your capacity as a state, what is the content of that commitment? Rather than attacking the procedural mechanisms that puts force behind the words in the international treaties, should we not be looking at what those words are? Isn't that the conversation we should be having? So this is sort of where I come from, and this is why we started looking at this in Stockholm. And I am a strong believer in sort of the expression that innovation lurks in the shadows between the silos. I think there's a lot of innovation to be done in between these two silos. And when addressing this topic here today, I also bring 3 other observations with me. I note our tendency as human beings to always try to create patterns in everything we do, to learn from the past, to trying to foresee the future. There are even those that argue that there are physiological evidence in our brains that leads us to overinterpret the surroundings of us to find patterns in everything that we experience. Those of you who have read the book Black Swan by Nicholas Taylor will know exactly what I'm talking about. And this is not always helpful for us. I also recall a conversation that was taking place in London last summer at a conference titled Business and Climate, where the president and CEO of Canada's largest energy company, Suncor Energy, and climate change campaigner, climate campaigner Tsipora Berman from Canada, who works as a strategic advisor to a number of environmental organizations, where they're together, were sitting on stage and describing a project, a dialogue they had been involved in about decarbonization of the Canadian economy. And they were both referring to this dialogue and this common objective as painful. A painful dialogue and a painful conversation to have, but necessary. And last, I think about the Swedish high jumper, Kajsa Bergqvist, who in the summer of 2004 ruptured her Achilles tendon, forcing her to completely redesign the way she did her training, only to come back a year later to break the indoor world record and to become a world champion. And I bring these observations here today because I think for us to be able to bridge the enforcement gap that is currently existing when it comes to sustainability objectives, we must free ourselves from patterns and the way we have done things before. And we must engage in painful dialogues. We must have tough conversations with an open mind and keep doors open when we perhaps would prefer to close them. And we must force ourselves to go about what we're doing in a completely new manner and not follow patterns. We must enter into uncharted territory. And if we do this, I am sure that we can do great things together to meet our common goals. And I think this is also what the climate change challenge is asking from all of us. I think we are all like the crew on Apollo 13 with a broken filter and running out of time. We depend on figuring out how to fit a square filter into a round hole. But just like the engineers on the ground in Houston was able to solve the problem those crucial days in April 1970, I think we can do the same. Today, as then, you will remember the phrase, failure is not an option. And like our friends at the crowdsourcing platform HeroX, and I will come back to that later, likes to say, the day before something is a breakthrough, it is a crazy idea. So moving then to the first of my 3 parts that I mentioned initially, I will say a few things with a brief overview of the current legal framework for sustainability objectives for energy and its enforcement, with an emphasis on brief. I realize there are many experts in this room that could dig much deeper than me into this topic, so I will share my observations from where I'm standing. Obviously, on this map, you will find the Sustainable Development Goals, the SDGs, Agenda 2030, which is a good, strong result of collaboration between nations, 193 to be exact, to achieve, and I quote, comprehensive, far-reaching, and people-centered goals. And I think from a communications perspective, the SDGs have been very successful. with a strong buy-in from the international community, including from the business community, which is very important. But one should keep in mind that the SDGs do not carry weight as legally binding or international enforceable obligations. So their implementation will in the end depend on countries' and corporations' willingness to put them into practice. Obviously, we have the Paris Agreement from 2015. We all remember the euphoria in December 2015 when 196 nations in Paris adopted the Paris Agreement by consensus. And since then, the agreement has entered into force. Today enjoys 197 signatories and 166 parties. And if we look at the language of the Paris Agreement, one could argue that it has elements that could be described as potentially more of a legally binding character. So some provisions include clear instructions to signatory parties, such as parties shall pursue domestic mitigation measures, and developed country parties shall provide financial resources, and so forth. And there are other provisions of the agreement that have been drafted in a more soft law style. Parties aim to reach global peaking of greenhouse gas emissions, and parties share a long-term vision, and so forth. The Paris Agreement also establishes a mechanism to facilitate and promote compliance to the agreement. So one could say that this mechanism supports the enforcement of the Paris Agreement, but it really does not deal with enforcement in the sense that we understand it in international arbitration. Again, the way that you can bring someone before an international tribunal if you were deemed to have broken your undertakings under this agreement, and to have a decision on this alleged breach to be decided by a tribunal in an award that can be enforced in a domestic court. So, in other words, there's really nothing in the SDGs or in the Paris Agreement addressing the consequences of a signatory party not living up to its undertaking as a signatory party. But this does not make these instruments unique from an international environmental law context. Remember Silo 2, right? That is rather the norm for international environmental law. Climate change conventions and international environmental law instruments typically lack strong enforcement language. And that has its explanation. From a policy perspective, it has not been possible to include stronger language in these instruments. But even if they are not directly enforceable, the way we understand it, again, from an international arbitration perspective, they send a very strong message of global consensus on these important issues, and that in itself could be extremely powerful. And I think the experience after the signing of the Paris Agreement confirms just that global buy-in can go a long way in reaching global goals, even if we don't have this sort of the strict legal enforceability contained in the language of the agreements. But we also know that political priorities tend to shift over time, right? So policy perspectives that were deemed necessary in August or December 2015 may not necessarily enjoy the same status 1 or 2 years later. Political agenda, climate policy and sustainability objectives has had a tendency to lose out. Some have even referred to this as the iron law of climate policy. If you put economic policy up against climate policy will lose every time. And I think recent events in this country illustrates the problem, where the president decided to withdraw from the Paris Agreement on 1st June. But this conflict is not unique for the United States. It happens in many other countries, including my own country in Sweden. We see this conflict. So where policy is shifting then, can we use other legal instruments to sort of enforce sustainability objectives? Which brings me to my second part of this talk, is to explore, or to say a few words about if you can use, or the potential use of other legal instruments to enforce sustainability objectives, sort of indirectly, even if sustainability is not the target of the agreement itself as such. And perhaps the experience from using these legal instruments can pave the way for increased effectiveness of enforcing sustainability targets in the future. On this arena, sustainability could be identified as sort of the actual outcome of the dispute at hand. But again, under an instrument other than the instrument actually laying down the sustainability objectives as such. One very practical example from the SEC caseload from 2013 would be a commercial case that was arising from a commercial contract between two international parties, but that was relating to a project in accordance with the joint implementation mechanism under the Kyoto Protocol. So that is sort of the connection between the international ambitions as laid down by states in the international agreements and the day-to-day commercial activities of private companies. One arena where sustainability objectives is really in the spotlight recently is international investment arbitration. And I think here specifically in the crossroads between investment arbitration and renewable energy ambitions. Sorry, investment protection. Investment protection and renewable energy ambitions, where these two sort of ambitions clash. As you might be aware, since 1959, there were more than 3,000 bilateral investment treaties concluded by states, and the majority of these include an ISDS clause where investors can file a claim against the states if there's an alleged breach of the investment protection terms of the BIT. And by the end of last year, UNCTAD reported close to 800 publicly known ISDS cases, and close to 500 of these have been concluded. And as of August this year, we have been looking at all the all of the pending ISDS cases in the public domain. And as far as we can tell, there are more than 50 international investment cases pending against states, primarily in Europe, where the claim originates from an investment in renewable energy. All of these cases are heard under the Energy Charter Treaty, but some of them are also heard under the SEC rules. They are under the Energy Charter Treaty, and most of them are decided under the ICSID arbitration rules. Some are under the SEC rules, and some are the UNCTAD rules. Investments in solar energy is the most common type of investment in these cases, but there are also examples of investments in wind, in biomass, and hydroelectric power. And the measures by states which have been challenged by investors include the change of the legal framework for the investments, more particularly feed-in tariffs and subsidies, alleged discriminatory measures relating to electricity pricing, a moratorium on the development of offshore wind power, alleged expropriation of hydroelectric power. Again, these are pending cases, so none of them have been decided. But there are some that have argued that investment arbitration can be used as a force of good, which can be used to motivate change by states in compliance with international norms, including norms then associated with sustainability or climate change mitigation and adaptation measures. And there are some interesting examples from international law. You may be familiar with the case of Peter Aller versus the government of Barbados, where the investor argued that the state was in breach of its treaty obligations due to failure to enforce both domestic and international environmental laws, including international environmental treaties. In this case, the tribunal rejected all the investors' claim in an award that came down in June this year. I'm not sure whether the entire award has been published. It might have been, but at least there are summaries available out there. But even regardless of the outcome of this case, the argument has still been made that it sends an important signal for environmental protection, and that a legal standard as laid down in a bilateral investment treaty can pave the way for future cases to help governments or to force governments to do enough to protect the environment. So where governments are held to not do enough to protect the environment, you could use the standard in the BIT. That argument has been made. But all in all, there are really no known international investment cases where which directly targets sustainability obligations by the states in the case. But perhaps in the future, we will see an arbitral tribunal reason on the relationship between the definition of public interest as contained in the concept of legitimate expectations and greenhouse gas curbing emissions as laid down in other instruments. That remains to be seen, but I think that will be an interesting reasoning to see. So, to the third part of this talk, about the investments needed to meet the sustainability targets moving forward. What needs to happen? What needs must be met for us on the planet to meet these targets? That's a long list of change we need to see, right? So we know that renewable energy plants must replace carbon-heavy ones. We know we need more energy-efficient transportation to transport an increasingly mobile and growing world population. And access to clean energy must become a reality for everyone on the planet. We know today there are about 2.5 billion people that either do not have access to energy at all, or their access to energy is what we call unclean cooking devices, right? That needs to change. We have a massive need for innovation in new technologies. And where there is new technology, we need to be able to put this technology up to scale, to enough standards. So this is just a few examples of all the things that need to happen. So we must make this transfer to a low carbon energy supply over the entire planet, while at the same time meet a general increase of demand of energy. So this is a very, very challenging equation, and I'm sure this is no news, of course, for anyone in this room. And there are many organizations that have ventured into putting a price on these investments that are needed. What is the size of these investments? And the numbers are very large. I'm quite sure you're familiar with them. We're talking about trillions of dollars annually on a global scale. And what I think is very clear is that the private sector needs to play a role here. The good news is, of course, is that the private sector is stepping up to the plate. The private sector is increasingly addressing this problem or this challenge. So large corporations are, to an increasing extent, turning to renewable energy, and they are investing in energy efficiency. And there's an overall increase in investments in clean energy at large. And that makes sense, because that goes directly to the bottom line. It makes good business sense, right, to invest in energy efficiency, but also it demonstrates leadership for these companies to make this transfer to a low-carbon economy. So maybe this is where we should turn to have the actual enforcement of the sustainability targets, to marry the business objectives, the bottom line objectives, what needs to happen for sustainability targets. What needs to happen for climate change mitigation and adaptation? So in this scenario, a strong legal infrastructure can support and make sure that the investments needed in support of energy-related climate change targets are, in fact, carried out. So, is this enough? Will the liberal economy sort itself out by itself using market forces? Well, if you look at the size recently of investments in sustainable energy, that gives rise for optimism, right? But I also learned recently that oil, gas, and coal still account for 86% of the world's energy mix, and that this figure has been constant for the past 25 years. So there is a lot to be done. And if you look at the pending cases, I have mentioned some, or the overview, particularly in international investment sphere, it reflects the volatility of policy and the conflict that comes with other targets. And it supports the hypothesis that policies for a sustainable future must be better designed to avoid this confrontation, real or perceived, between economic growth policy and climate policy. Whether or not this is a real or perceived conflict doesn't really matter, but it's there, and it has consequences. And right now we see this conflict too often. And there is a tendency that sustainability objectives, again, when you have this conflict, that those objectives lose out. And there is uncertainty created by this conflict, actual or potential or perceived. And uncertainty regarding government policy is many times cited as the most common reasons why you don't see enough investments in, for example, sustainability targets, why we don't see enough investments in renewables. We're explaining why green investments are either delayed or withdrawn entirely, because there's a perceived risk, rightfully or wrong, of regulatory changes, and that is seen as making it difficult to make the investment. So you have companies that simply refrain from making the investments needed because they find there is no appropriate policy framework. And to have enough FDI, to have enough investments for sustainability objectives, for climate change mitigation and adaptation, government investment policies must be more predictable, they must be more stable, and they must be more transparent. So then, coming to the end here, to summarize these three parts, I have mentioned the legal framework for sustainability objectives does really not provide strong enforcement tools. We were looking at other existing legal instruments that you can use to put force behind the words in other contexts, and that can be done, but with varying results. And third, we know that there is global investments, they are in dire need to have a stable policy framework in place to have these investments happening. So, with these three pieces of the puzzle, if you will like, where do we go from here? So let me then return to my initial promise to offer a proposal on how to connect these three perspectives, or these 3 points of observations, and perhaps in the end achieve an even stronger enforcement tool for sustainable development goals. The initiative that we call the Stockholm Treaty Lab. In short, the Stockholm Treaty Lab is a competition for the creation of a completely new type of a legal instrument which incentivizes growth in support of sustainable targets. I have no idea how to do this. But that's the point, right? We don't know how to do that. And we are a small group of people at the SCC or with the institutions that we work with. But there are lots of smart people out there. And they become even smarter as they collaborate with one another. So the way we have decided to solve this problem is through an innovation prize. This is a competition, a global competition to create policy. So we have designed this as a crowdsourcing initiative, and we are working together with HeroX, like I mentioned before, which is a crowdsourcing platform based here in the United States. And today we have no less than 22 teams that have already registered to be part of this challenge. And registration is open until the end of the month. And here we're looking at truly multidisciplinary teams. So not only the lawyers, the policy people, the climate specialists, the people negotiating agreements on behalf of their states, macroeconomists, and what have you. Whatever specialization you think necessary to solve this problem. And we're doing this in collaboration with the International Bar Association and the Stockholm Environment Institute and the Haga Initiative in Stockholm. And we have strong support, very happy about that, from many experts around the world, including people in this room. And if you want to find out more, because I think now there's not time for me to really go into all the details, you can visit the stockholmtreatylab.org or herox.com and search for the Stockholm Treaty Lab, and you can find out everything about the competition. And like I said, registration is open until the end of October. So, with this, I come to the end of my remarks here today, and I do hope that you will join me in breaking the patterns, keeping doors open, and redesigning the way we do things. Because I think that's the only way that we can solve this challenge, and to bridge that enforceability gap, and to put force behind the words in long-term global goals, and perhaps in the end, make our grandchildren proud of us. Thank you for your attention.
Take a few questions.
Sure.
So we welcome questions now. Just one general point. This is being broadcast, so please scream so the broadcast picks it. It's a question if there's a question mark at the end. Julian.
Hi. So Client Earth has had many successes in taking the British government to court.
Sorry, I didn't hear the beginning.
Client Earth, the
Okay,
legal
Client Earth, yeah.
in the last 2 years has had 3 successes against the relevant UK government ministry, and forcing the ministry to firstly fashion and then rethink its proposals to meet its EU targets to lower emissions by a certain year. And my question is, does the SEC envisage a role for domestic courts in any kind of dispute resolution mechanism it envisages in this model treaty? Because as far as I can see it, from the perspective of the actual beneficiaries of these policies, the people who live in these countries themselves, they're more likely to sort of find favour with their domestic courts enforcing these policies than some sort of foreign court staffed by some foreigners who don't know what's going on in their country.
Like I said, I don't know how this instrument will be drafted, and I think anything is possible. What we have made as a criteria is we want some sort of enforcement mechanism. I think that is we found that important to put force behind the words, like I said. But I think it's a clean sheet of paper. So whichever way contestants decide to design this to achieve that, anything is possible.
You have a question back there?
Yeah, question. Lena from Poland, spent some time in Switzerland, working in-house for the past 7 years. And the question I have is there any work being done to mobilize in-house counsels and, in general, in-house people working for large multinationals to also support the shift? Because I think if we address the problem from many angles, and if we do that not only through one instrument or this instrument or changing policies, not changing, but involving everyone, I'm thinking about the concept of intrapreneurship, where there are individuals who have some ideals to pursue and want to make sure that their companies where they work really focus on the right goals. So I was wondering to what extent Chamber of Commerces could typically have like open discussions with people working for those organizations and providing some tools to have them like foster those goals. Because again, if we work all together and we address the problem from many angles, there is likelihood that there will be the chances are that we will manage to change to shift the paradigm more easily and more fluently. Because again, the in-house people know the business and they have the means to talk to the business because they know what the business fears and where the business could find the added value and be really interested by certain options that they would not take into consideration.
I think that's a very valid observation. I think it's important to have the private sector involved, including the General Counsel, and given the changing role of General Counsel recently to become more involved in the business objectives of their operation and being a sort of a strategic advisor to the CEO in business matters, I think it makes absolutely sense. And we can probably do more in that regard in terms of involving the General Counsel in this discussion as well. Absolutely. We have done some, but we can probably do more.
Get a question from Peter right there.
Hi, Ms. Magnusson. Thank you very much for your inspiring talk. I think we in this room especially agree that there should be an enforcement mechanism for sustainability obligations of the states. My only worry is that if you think that the big states would be on board. So historically, the capital exporting countries like the US, Germany, France, Holland, were incentivized to sign BITs with smaller countries, capital importing states, because they knew that they will essentially never be sued, or at least in the next couple of decades. But in this case, exactly the capital exporting states would be the ones who are very likely to be sued under any sort of enforcement mechanism in this treaty. So do you think that the bigger states would be on board as well?
Well, I think first we have to move away from the concept of BITs. If you're talking about the Stockholm Treaty Lab, we are in a new territory, so we're doing something different. I understand, since that's sort of the model we have and that has been used, it's easy to sort of step into that room and say we should sort of modify what we have. But I'm hoping we will see proposals that is completely something else, but that are attractive for both capital importing, capital exporting countries. If we decide to sort of categorize countries like that. Because I think that's the key, right? There needs to be an upside for everyone involved, and that upside needs to be so attractive that you are interested in in the enforcement mechanism itself as well.
Right, but therefore, as a follow-up, if I make it clear, then what is the enforcement then? Because this is very abstract, right? So what we know today, we have remedies essentially twofold: specific performance and damages as an enforcement remedy, right? So in this case, I'm just very, and I don't want to play the devil's advocate here, but I am now. So I just doubt that any sort of enforcement mechanism is going to bind, say, the U.S. by a specific performance to uphold a certain amount of gas that it exposes to the environment. So I'm just wondering about the practical remedy that any sort of enforcement mechanism can come up.
Now this is the square filtered into the round hole you're describing there, right? So again, I'm not saying it's easy, but I'm saying we have to figure this out to solve this problem, so that it will become attractive. And again, I leave it up to the teams to see how they can do that.
Any other questions? Yes.
Thank you so much for the talk, first of all. Just one question. When countries come up with clean energy policies, more often than not, they have a tendency to sort of preload them with certain other objectives, primarily because of political economy considerations, either because you want to generate employment, because you're moving away from dirty energy, you're coming to clean energy, you want to create jobs, local content requirements, things like that. So even there you have a similar sort of a dispute happening, the dilemma between meeting political economy considerations and promoting clean energy. Now, countries have been taken to disputes because of this reason, either by investors or even at WTO. So how do you resolve this dilemma? Do you do it at the dispute level? Do you do it when you frame the substantive content of the treaties? Is it in the wording of the treaties? Where do you find the answer to this dilemma?
No, you're describing a very important conflict here between different policies that could be equally pressing if you are the political leadership of the country, right? You want to have employment for your population and you want to have the clean energy. And how do you make that shift if you are an economy that is very carbon heavy? And I don't have an answer to that. I don't have an answer how you solve that problem. And I think part of why we put this out there is to see what can be done if you think about this problem, or if you think that the objective from fresh to the extent that's possible, giving our own experiences. But you're pointing at that sort of describes the challenge in a very good way.
I would urge everyone, log on to this Treaty Lab website, look at it. It is a really cool project, and we hope many students from Columbia sign up. Any other questions? Oh, sorry, Matteo.
Oh, yeah. Do you think that this new instrument, you can call it a treaty, multilateral treaty, whatever, should focus only on the investment law, so trying to attract foreign direct investments, or should also attach some topics regarding trade between countries? Because otherwise it would overlap with WTO system, and maybe that would lead to some conflict.
I think whichever systems you need to address to have the change on the ground happen should be taken into consideration when you start out with your clean sheet of white paper, right? So the way we started thinking about this is that, okay, we described it as legal re-engineering. So we know that all societies need to make massive changes to meet the climate change challenge, regardless whether you are in New York City, whether you're in Stockholm, whether you are in New Delhi, or whether you are in Nairobi, wherever. Changes might be different, but there will need to be changes. And for those changes to happen, what needs to happen from an economic scale, right? Investments. But I suppose there could be trade as well. What needs to shift to enable that? And how do we then reflect that needed shift in legal language? I don't know if I answered your question, but I think one should not limit oneself. I suppose that's the short answer.
I'm going to invite everybody to give a very warm Columbia thanks to Annette for coming out. It is a long flight to Stockholm, and you are a busy lady. Thank you very much.
Thank you so much.
The bag is deceptive, but it is cool stuff.
Okay.
We also thought we could be a book with New York.
Thank you so much.
Thank you very much.
Thank you. Thank you.
You can use the next few minutes to ask Annette questions that you were scared to ask on the video. This is a rare opportunity, so do take advantage.